Hi friends, in this video we are going to deal with the important judgment titled as PRABHA TYAGI versus KAMLESH DEVI, pronounced on 12th May 2022. In this judgment, the Supreme Court has held that every woman in a domestic relationship has a right to reside in the shared household even in the absence of any act of domestic violence. She cannot be evicted, excluded, or thrown out from such a household, even in the absence of there being any form of domestic violence. The facts of the case would be that after the death of her husband, appellant as aggrieved person approached the special judicial magistrate under section 12 of the Protection of Women from Domestic Violence Act 2005 and sought protection, residence and compensation orders to be passed under various provisions of the act. Further prayers were also made for monetary reliefs under section 22. Though the magistrate granted some relief, ultimately the Uttarakhand High Court held that in order to establish that the respondents committed violence as contemplated under the Act, it is required that the aggrieved person was sharing a household with the respondents and there was a domestic relationship between the parties. Being aggrieved, the present appeal has been filed with the allegation that the High Court and the First Appellate Court erred in setting aside the judgment of the Special Judicial Magistrate on the primary ground that aggrieved person was not sharing a household with the respondents and there was no domestic relationship between the parties and therefore no relief could be granted under the provisions of the Act. Further, the issues raised for the consideration are whether the consideration of domestic incident report is mandatory before initiating the proceedings under the Act in order to invoke substantive provisions of sections 18 to 20 and 22. Whether it is mandatory for the aggrieved person to reside with those persons against whom the allegations level at the time of commission of violence, and whether there should be a subsisting domestic relationship between the aggrieved person and the person against whom the relief is claimed. The Supreme Court has held that Section 17 speaks of right to reside in a shared household, while Section 19 deals with residence orders which could be passed by a magistrate while disposing of an application under Section 12(1) on being satisfied that domestic violence has taken place in a shared household. Thus, while Section 19 deals with residence orders, the right to reside in a shared household is dealt with in Section 17. Section 17(1), which begins with a non-obstantive clause, states that notwithstanding anything contained in any other law for the time being in force, every woman in a domestic relationship shall have the right to reside in the shared household, whether or not she has any right, title, or beneficial interest in the same. Section 17(2) states that an aggrieved person shall not be evicted or excluded from the shared household or any part of it by the respondent save in accordance with the procedure established by law. The distinction between Section 17(1) and 17(2) is also to be noted. While subsection 2 deals with an aggrieved person, which is defined in section 2a in the context of domestic violence, subsection 1 of section 17 is a right conferred on every woman in a domestic relationship, irrespective of whether she is an aggrieved person or not. In other words, every woman in a domestic relationship has a right to reside in the shared household even in the absence of any act of domestic violence by the respondent. The expression shared household is defined in section 2s, but the expression contained in section 17, namely, every woman in a domestic relationship shall have the right to reside in the shared household, irrespective whether she has any right, title, or beneficial interest in same, requires an expansive interpretation. While the object and purpose of the Act is to protect a woman from domestic violence, the salutary object of subsection 1 of section 17 is to confer a right on every woman in a domestic relationship to have the right to reside in a shared household. Hence, the said provision commences with a non-obstantive clause. Though the expression shared household is defined in the context of a household where the person aggrieved lives or has lived in a domestic relationship, either singly or along with the respondent, in the context of subsection 1 of section 17, the said expression cannot be restricted only to a household where a person aggrieved resides or at any stage resided in a domestic relationship. Thus, a mother, daughter, sister, wife, mother in law, and daughter in law, or such other categories of women in a domestic relationship, have the right to reside in a shared household, has a right, title, or beneficial interest in the same. Further, the expression the right to reside in a shared household cannot be restricted to actual residence. The expression right to reside in the shared household is not restricted to only actual residence, as irrespective of actual residence, a woman in a domestic relationship can enforce her right to reside in the shared household. Thus, a woman cannot be excluded from the shared household even if she has not actually resided therein. That is why the expression shall not be evicted or excluded from the shared household has been intentionally used in subsection 2 of section 17. This means if a woman in a domestic relationship is an aggrieved person and she is actually residing in the shared household, she cannot be evicted except in accordance with the procedure established by the law. Similarly, a woman in a domestic relationship who is an aggrieved person cannot be excluded from her right to reside in the shared household except in accordance with the procedure established by the law. Therefore, the expression right to reside in the shared household would include not only actual residence but also constructive residence in the shared household, that is, right to reside therein, which cannot be excluded vis-a-vis an aggrieved person except in accordance with the procedure established by law. If a woman is sought to be evicted or excluded from the shared household, she would be an aggrieved person, in which even subsection 2 of section 17 would apply. The Act is a piece of civil code which is applicable to every woman in India, irrespective of her religious affiliation and or social background, for a more effective protection of her rights guaranteed under the Constitution, and in order to protect women victims of domestic violence occurring in a domestic relationship. Therefore, the expression joint family cannot mean as understood in Hindu law. Thus, the expression family members living together as a joint family means the members living jointly as a family. In such an interpretation, even a girl child, children who is or her cared for as foster children also have a right to live in a shared household and are conferred with a right under subsection 1 of section 17. When such a girl child or woman becomes an aggrieved person, the protection of subsection 2 of section 17 comes into play. Therefore, it is not mandatory for the aggrieved person to have actually lived or resided with those persons against whom the allegations have been leveled at the time of seeking relief. If a woman has the right to reside in a shared household, she can accordingly enforce her right under section 17(1). If a woman becomes an aggrieved person or victim of domestic violence, she can seek relief under the provisions of the Act, including her right to live or reside in the shared household under section 17, read with section 19. Hence, the appellant had the right to live in a shared household, that is, her matrimonial home, and being a victim of domestic violence, could enforce her right to live or reside in the shared household under the provisions of the Act and to seek any other appropriate relief provided under the Act. This is irrespective of whether she actually lived in the shared household. Facts on record would show that even though, as on the date of filing of the application before the magistrate under section 12, the appellant was not actually living in the shared household, she nevertheless lived in a domestic relationship with her husband and further had the right to reside in the shared household as a daughter-in-law. The appellant as aggrieved person had to leave the shared household on account of her harassment and mental torture given to her by respondent, mother-in-law, and her family. She had to leave the same and fend for herself. Thus, as an aggrieved person, the appellant could not have been excluded from the shared household as there was no valid reason to do so. as the appellant had a right to reside in the shared household as she was in a domestic relationship with her husband till he died in the accident and lived together with him. Therefore, she also had a right to reside in the shared household despite the death of her husband in a road accident. The aggrieved person continued to have a subsisting domestic relationship owing to her marriage, and she, being the daughter in law, had the right to reside in the shared household. In the instant case, when the proviso is read in the context of the main provision, which begins with the words an aggrieved person or a protection officer or any other person on behalf of the aggrieved person may present an application to the magistrate seeking one or more reliefs under the Act, would indicate that the aggrieved person can by herself or through her advocate approach the magistrate for seeking any of the reliefs under the Act. In such an event, the filing of a domestic incident report does not arise. If the intention of the Parliament had been that filing of the report by the protection officer is a condition precedent for the magistrate to act upon the complaint filed by an aggrieved person, even when she files it by herself or through her advocate, then it would have been so expressed. But a conjoined reading of subsection 1 of section 12 with a proviso does not indicate such an intention. Thus, the plenitude of power under section 12 is accordingly interpreted and prerequisite for issuing notice to the respondent on an application filed by the aggrieved person without the assistance of a protection officer or service provider, and thus there being an absence of domestic incident report does not arise. If a contrary interpretation is to be given, then the opening words of subsection 1 of section 12 would be rendered odious, and it would be incumbent for every aggrieved person to first approach a protection officer or a service provider, as the case may be, and get a domestic incident report prepared, and thereafter to approach the magistrate for reliefs under the Act, which is not the intention of the Parliament. To sum up, section 12 does not make it mandatory for a magistrate to consider a domestic incident report filed by a protection officer or service provider before passing any order under the Act. Even in the absence of a domestic incident report, a magistrate is empowered to pass both ex parte or interim as well as a final order under the provisions of the Act. Also, it is not mandatory for the aggrieved person, when she is related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family, to actually reside with those persons against whom the allegations have been leveled at the time of commission of domestic violence. If a woman has the right to reside in the shared household under section 17, and such a woman becomes an aggrieved person or victim of domestic violence, she can seek reliefs under the provisions of Act, including enforcement of her right to live in a shared household. Further, there should be a subsisting domestic relationship between the aggrieved person and the person against whom the relief is claimed vis-a-vis allegation of domestic violence. However, it is not necessary that at the time of filing of application by an aggrieved person, the domestic relationship should be subsisting. In other words, even if an aggrieved person is not in a domestic relationship with the respondent in a shared household at the time of filing of an application under section 12, but has at any point of time lived so or had the right to live and subjected to domestic violence, or is later subjected to domestic violence on account of the domestic relationship, is entitled to file an application under section 12. Therefore, the judgments passed by the High Court and the Session Judge are set aside, and the order passed by the Special Judicial Magistrate is affirmed.